Welcome to Trial and Medical Error, where we bridge the gap between medicine and law and unlock groundbreaking trial techniques. Join hosts Brendan Lupetin and Greg Unatin as they share novel insights and strategies to help you confidently tackle the most complicated cases. Produced and powered by LawPods.
In today's episode, I talk with attorney Clancy Boylan, who is not only an amazing trial lawyer. We're going to talk about an awesome trucking verdict with massive punitive damages he got just a couple months ago. He's also the managing partner of the New Jersey and Philadelphia offices of Morgan & Morgan, the largest personal injury firm in the country. Clancy talks about his background, what got him into trial work, and the approach he uses to working up his cases, specifically trucking cases, and the secrets to success that helped him and his partner obtain a $26 million verdict in a trucking case that happened before the pandemic, was tried after the pandemic. A lot of great stories, a lot of great ideas and concepts that anybody can use and apply to their cases, not just trucking cases. And also a lot of great discussion on how to approach and work up damages and arguments for punitive damages. You'll get a lot out of this episode. Here's Clancy Boylan. Thanks so much for being here, dude. I know you just got literally shaken up on a flight down to Florida, and I appreciate you overcoming that air terror to be here to talk about some awesome results that you've gotten lately. So thanks so much for joining me on the podcast, dude.
Absolutely. Thanks for having me.
Yeah, this is great. I'm super pumped. Got a ton of questions for you. The first reason I wanted to get you on is to talk about this Clemens case where you got this monster trucking punitive verdict. And the way I heard about it was I'm on a PA MedMal listserv, and I think it was Marion Munley was like, off topic, monster verdict. And I'm like, what the hell is this, and reading about it. And it just sounded awesome. So super excited to hear about that, and definitely have some major questions about how you used some of the medical evidence in that case to get the verdict and whether you did. But before we get there, I have some other questions for you. So first off, I'm reading about you. You seem like a pretty freaking young dude, and you are managing partner, Morgan & Morgan in Philly and Jersey. And at least what I read, you were managing 30 people or something like that.
Yeah, I think we're close to 30 attorneys now, maybe just over that. And total staff, probably about 130, 140.
This is in your region, what you're overseeing.
Yeah, my region. I started about 5.5 years ago. It was just me.
And right, that's a very quick growth curve. And then you're trying cases on top of it, and you've got a family. So my first question is, what is your secret to productivity or time efficiency? What is it? How do you do it? Or is there none? You just work 24 hours a day.
No, I don't work 24 hours a day, but I do work a lot. Thankfully, my family understands. I think the key for me is I can go in on a Saturday or Sunday and bang out 4 hours, and that's more productive for me than the entire week because nobody's bothering me, nobody's calling me, and I can kind of get ahead.
Yeah, I that resonates a lot with me when I was a little bit younger and I was really trying to kind of establish myself and everything. I switched to this current firm that eventually I was able to take over, much smaller operation than what you're overseeing. But yeah, it was like Sundays. Sundays was the key. I had an understanding wife, and she was okay with me going in and just basically working all day Sunday because that was for whatever reason. You weren't bothered. And you could just crush out stuff, and then it kind of, put you in a good, headspace for the rest of the week. So I can see that. I still don't know. I feel like you must have some kind of other secret deal with some kind of, and I don't know what, but I don't know how you're pulling this all off because some spectacular verdicts on top of, running that section of a massive firm. So tell us a little bit about, how did you get here? I saw you're from the Northeast originally, right?
Yeah, I was born and raised in Kingston, just across the river from Wilkes-Barre.
And then Duquesne Law.
Duquesne Law, yeah. I went to St. Joe's University in Philadelphia. When I graduated from there, no idea what I wanted to do. And I got into banking for about 3 years and realized I absolutely hated it. They micromanaged you. There was no creativity. And I kind of always wanted to be a trial lawyer. So I went to my boss, and he wanted me to move up. And I said, I want to leave. I said, I want to take the LSAT and go to law school. And luckily, he kind of kept it under the table. I did that, went to Duquesne. When I visited there, everybody told me law school was going to be this like cutthroat, everybody's out to get each other. And I showed up to Duquesne, I walked in front door, Hanley Hall, and it was like a second or third year person looked at me. He's like, "You look like you're lost." I said, "Yeah, I'm just trying to figure out if I want to go here." And they took me through a quick like 5 minute tour, and I kind of knew right then that this was probably going to be the place for me. Plus, Pittsburgh was a great city.
Yeah, no, that's awesome. My associate Maggie that works with me, who's a phenom, just an amazing person. She went there and just, I'm a Pitt guy, but no, she raved about her experience at Duquesne Law. That was before Tom Klein renamed it after himself, right? So
Yeah, I sent Tom an email when he did that. I said, "Thank you from the bottom of my bank account for giving all that money."
yeah, yeah, no kidding, man. So what was if you look back, you said even though you went into banking, you always wanted to be a trial lawyer. Do you have like a sense of where that came from, or was there something that motivated you?
Just something that, is one of those things where, you're growing up and the performance aspect of it, helping people, for whatever reason it was, it just always resonated with me. I just wasn't ready when I got out of college. And so I'm glad I had those 4 years off, kind of gave me a better perspective when I was at Duquesne. I got involved in the trial ad program. We won the national championship, got to go to LA, Las Vegas, Waco, Texas for the Top Gun. And so I left there and I went to work for a PI firm in Kingston with Ed Ciramboli, Greg Fellerman.
I
I
know
was
Ed well.
there. Yeah, it's a great guy. So I
Awesome.
learned, a lot of trucking from Eddie. The business aspect I learned from Greg, that both, were mentors of mine. After 2 years of being in Kingston, my wife absolutely hated it. Getting her to come from Pittsburgh to Kingston was the greatest sell job of my life.
Oh, so she's
Uh,
from Pittsburgh.
yeah, she
Oh,
was a
gotcha.
South Hills girl.
Oh, okay,
Yeah.
gotcha. Very cool.
So and I didn't want to be home. I didn't want to be a big fish in a small pond, and I convinced Eddie and Greg to send me to Philadelphia to open up a satellite office, and for whatever reason they agreed to do it. And I showed up there and we called it guerrilla warfare. Just pound the pavement, talk to as many people as possible. I was going into every home in North Philly, West Philly, South Philly, just trying to drum up business.
When you were in law school and you're going the trial ad path and obviously very good at it, did you think you wanted to go into, contingency fee plaintiff personal injury, or were you thinking criminal defense or any other type of trial work?
Crim Sci never really resonated with me, and I knew I didn't want to defend, corporations or businesses. I wanted to represent somebody who, whose life was altered, family life, everything like that. I wanted to represent that person and fight for them. So I kind of knew right off the bat, like plaintiff's law was what I wanted to do, and luckily, and I got the opportunity with Eddie and Greg because not a lot of people are fortunate enough to be able to get into plaintiff's law right off the bat because it's kind of small, smaller community.
When were you able to, basically first leading trying cases?
So I got barred October 2012. I graduated June 2012, was barred October 2012. And within 3 months, Eddie came in my office, said, "Do you want to try a case?" I said, "Sure." I think it was like a Wednesday. Handed me the file. It said, "You're picking a jury on Monday."
Nice.
So I got right into it. And I got to tell you, trial ad, prepared us openings, closings, cross directs, like all that stuff. I wasn't nervous at all. And I realized I had to pick a jury and I had no clue how to do it. No idea what I was doing. There was no law school class about it. So I was just like crapping my pants thinking about it. And in Luzerne County, you play the people off of each other. And, once you do it once, the fear goes away. But that was like the scariest thing. So, but I tried that. I tried probably two more, what Greg would call suicide missions in the first, year of my being a lawyer. And then we got to Philly. We tried one in Philly, and then I came to Morgan, and then have been able to try a bunch, recently as our cases have matured.
Yeah. So was there a gap in that period of time when, you're getting started, you're getting that, office off the ground, you're the sole guy. I can't imagine you're flying into trial right off the bat, right?
Yeah, no, it took a little bit for the cases to develop. Also, COVID hit. That was that. And also, one of the, Philly's a great venue to try a case, but it's also a tough venue if you want to try cases because a lot of times, they're giving you the money and the clients, there's no way they're going to say, "Hey, let's turn this down and go try the case." But, recently with the trucking cases where we've got a lot of coverage, usually great injuries, it's easy to kind of just convince our clients that they should roll the dice.
So, and obviously Clemens is a trucking case. Before we get into it, you're in the Morgan & Morgan fold now. And so obviously you have access to a bunch of amazing resources like Mitnick, and I'm sure a bunch of other, kick-ass trial lawyers within the organization. But separate and apart from, what you've gained internally, what have you done? Like, what would you say are the biggest influences as far as like how you try cases, how you do your opening, how you approach order of proof or your strategy or so forth?
It came from one from Eddie and Greg, and then from Morgan & Morgan as well. Eddie and Greg, the biggest thing they always said is just be the most credible person in the courtroom. That helped strategize, like, hey, is there a weak part of our case that we can just forget about it? Is the back, he's got 30 years of priors. Do we need to get into that? Let's just focus on the neck. So I got a lot of that from them. And then Mark Nation at Morgan, he was a big proponent of just come out swinging. And especially like in my depositions, especially in tractor trailer case, my first question, I don't even read them instructions. You ready to go? They say yes. And I say, all right, why'd you run into the back of my client? And then they're just, from there, it's just pile on them. And then, within 20 to 30 minutes, you could usually break them. And then they give you, everything. So when it comes to trucking, same thing. It's like we're putting on either the corporate rep or the driver first, and we're just getting started. We beat them up and then put on our liability expert, and then we roll into the damages.
That's the formula you've been finding is successful for you lately?
Yeah, especially in trucking, like, what's going to drive a verdict? Obviously, injuries are a driver. But for me, I think the single biggest driver is the PO factor, the piss off factor. And if you can get that jury angry right from the bat, if your medical's not the greatest, they can overlook that because they're mad, and that'll get reflected in the compensatory, and it'll drive the numbers up.
Yeah, I don't know how much, big data stuff you guys have done. I'm sure within Morgan you guys are doing. I don't know how much you've done, and I'd be interested to hear. But John Campbell, who was formerly Empirical Jury, now it's, Campbell and Campbell Law Group, they were talking on another podcast recently that that's really what they find. I mean, and we've heard that for a while, that the anger probably and piss off factor is probably the biggest factor that is driving verdicts in most cases. And trying to find that way that you can create that. I think in some cases are better set up for that. I, for some reason, chose the crazy course of doing mostly medical malpractice. And so sometimes it's a lot more difficult to find a way to get the jury pissed off. But it does happen. But I imagine it can happen in the right cases a lot in trucking companies, trucking case, and you got the big corporate entity and everybody's afraid of the tractor trailers and so forth. Do you have a particular structure you follow in your opening statements, or is it kind of case dependent?
Yeah, you know what? I would be remiss if I didn't mention the fact that the resources at Morgan Morgan between Keith Mitnick, Brian McLean, Rick Block, and we've got some tremendous female attorneys. We got, Kelly Lester, Jen Rosinski, a whole bunch of people that, in my case last week, couldn't structure my closing. I had so many thoughts in my head. I texted Keith, and within 30 seconds, he's calling my cell phone, talked to me at 10 o'clock at night for 30 minutes. So that's just incredible that we have that. But for opening, the structuring it, I like to get my theme right off the bat. For trucking cases, a lot of times, they're not following the rules. A lot of times in my depositions, I find out they don't even know the rules. So to follow the rules, you got to know the rules. Speeding's always a big one. Speed kills, and lastly, it's taking responsibility. A lot of times, and we'll talk about this in the Clemens case in my last trial, despite smashing into the back of my clients from behind, they're still challenging liability and they're not accepting responsibility. And that is one of the single biggest drivers of the piss off factors. When you got a company coming in and a jury's like, why aren't you saying I'm sorry? And here they are trying to tell you that, it's not their fault for blaming my client who's just sitting there in a vehicle. So I like to hit, and then I go in order, liability first. We're going to prove to you liability, walk them through basic. I like to keep the opening as short as I can. And then we're going to prove to you damages, economic, non-economic, and then, out piece and sit down and let the other side get up there and talk for, 45 minutes.
Got it. So let's talk about Clemens. Trucking crash back in 2019. I'm guessing Patrick Clemens was your client, the driver of another tractor trailer, right?
Yep. Yeah, he had pulled over on Route 30 in Lancaster. Mr. Clemens was an old school driver, didn't use GPS, so he was kind of making a new route. It's a little after midnight, and so he pulls over, puts on his four ways, fully off the road, and he's checking his maps. A minute later, boom, from behind, gets hit by an E-Core tractor trailer.
I have a lot of questions about this, but what are his, I mean, the pictures are pretty compelling, gets smashed in the back, a lot of major visible property damage, so no issues there. What are the injuries? I'm seeing spine and brain.
Yeah, so two things. The pictures were great. I mean, it shows a lot of damage. The problem is being in an 80,000 pound tractor trailer himself, it lessened the impact to him up front. Neck and back, had a herniation in the neck, had a herniation in the back. He had, headaches and some fogginess, but he didn't really treat for that until about 8 months post crash, where he finally sees a neurologist and they diagnose him with post concussive, and he does some vestibular therapy, cognitive therapy. He got an RFA in his back, low back, and then the treating surgeon recommended surgery for his neck and back, but during COVID, he didn't want to run the risk. And then also he had ticker issues, and he needed to get clearance, and the risk outweighed the benefits for surgery. He could still play golf, so he held off on that. So we didn't have any surgeries.
So, okay, so non-operative spine case with, quote, mild TBI, basically, right?
Correct.
Okay, which is that's an amazing background to set up this verdict that you got. But I'm putting the cart before the horse a little bit. Walk me through how you developed. I mean, what were the key points of liability, and were there a number of them, and you pared it down to just a couple, key ones, or what did you think was the driver as far as your liability case? Did they admit liability first off?
They did not.
Okay.
So one of the things that, I get the police report, I see that, the police officer lists that the conditions were slippery, snow, wet, ice, it was snowing at the time. So that brings in 392.14, the FMCSRs. And those are some of my favorite cases because, what I've found is that the drivers, they don't know the rules. The companies aren't enforcing it. They're not teaching them about it. So in rain, you got to cut your speed by a third. In snow, you cut it by half. And on ice, you should only be crawling. And, what we see is the tractor trailers are going the speed limit, despite, heavy rain, despite snow. And that causes issues, as you can imagine. You've got an 80,000 pound tractor trailer, and in those conditions going, 60, 70 miles an hour, bad things are going to happen. They can't control it. They can't steer it. They can't stop it in time.
So that reg is one of your favorites, and I'm guessing you kind of centered your whole case around that, the clear violations of it.
Correct. So we get into it, and then I found through some GPS data that the guy, in the 30 days leading up to it, is going what I thought was 5 to 10 miles an hour over the speed limit, and I ended up at trial making it up to 15 miles an hour, and I guess we'll get to that a little later. That was one of those trial techniques that you use that.
Well, if you want to jump into it
you
now,
shouldn't be using.
Well, no, come on, you can't, set it up and then I'll probably forget about it. So yeah, what happened?
So the guy, E-Core is basically like a flooring company. They had two plants, one in Lancaster, one in York. And so the guy, he goes across 30 and down 70, and he just keeps doing that back and forth, back and forth, back and forth. And I was fairly confident that the speed limit on 70 was 65. But my partner, who I tried the case with, Hannah Torres, I was like, let me go for this. And she's always, like, don't do it. So I get up there and I was like, we have your GPS speeds, you're going this amount. So going across 70, we know that's 55, right? He's like, yeah. And then going down 70, that's 55 as well, right? And he goes, no, I think it's 65. And I go, whoa, but below George Street, it's 65. And I have no idea if George Street is even a thing. I go, George Street's below your plant, right? And, they're on the stand and they have no idea what to do. He's like, yeah, you know what, you're right. And so the speeds there, that triggered it, got it all the way up to 15 miles an hour, the speed limit.
Oh, because now he's saying, it's probably 55, and what he was going. Gotcha.
Yeah. So, but that's what I learned in discovery, is that, this guy's flying all over the road. And then we get into depositions. He admits it. And then I had like a PowerPoint that I created where I was just, every time they answered, I filled it in. And 392.14 says you got to use extreme caution. So I said to him, what's your definition of extreme caution? And he goes, be a little safer. So I like typed that in. I was like, that should, I go, my definition of extreme caution is, caution to the highest degree. Yours is a little bit safer. He's like, yeah, that's what I would say. And I asked him, all right, well, what do you think you need to do on wet roads? He's like, you can just drive the speed limit. All right, what do you need to do in snow? And so the guy should have been going, speed limit 55, so he should have been going 32, 33 miles an hour. He was actually going 63. We knew that about 30 seconds before impact. So, 8 miles over the speed limit and about 28 miles an hour more than he should have been going. And there was no skid marks, no nothing. So, the jury can just assume that, all right, when he hit my guy, he was about 63. And then I asked him, what did your company do? Did they know you were going, 5 to 10 miles an hour consistently over the speed limit? And he goes, yeah. I go, what did they say? He goes, just be careful. I go, would you take that to mean? He goes, that it was fine.
Oh, nice.
And then I get the safety guy in there, and here's a guy that's responsible for knowing FMCSRs, the CDL manual. He didn't have a CDL license. He never read the CDL manual. He had no idea what 392.14 was about. And then it's just having fun from there with that. So I've got it all teed up on liability.
Wait, let me jump in there for a second, because you mentioned something that I thought is interesting. So were you using during these depositions a PowerPoint to fill out information that they're providing you at the time?
Yep.
Can you describe for us what it is and how you use it?
So I am, my associate calls me a boomer when it comes to technology. I had just a very basic PowerPoint. But on the left-hand side, it would say the speed you were going, 63, speed limit 55. What speed should you have been going in rain? And he'd say, speed limit 55. And then on the right side, it was like what the answers should have been. And then I got the safety guy in there too, and I matched up, his answers. And again, he was basically the same thing as the driver. He agreed. He goes, yeah, extreme cautions. I'd agree with, just a little safer. So I didn't end up using those at trial, but right there, again, with both these guys, just starting right from the start, the amount of money that we ended up, getting offered that we turned down was, probably way more than anybody thought that case was going to be offered.
Because of the, allegedly minimal injuries, right?
Yeah.
So why didn't they, you paint a picture of a pretty damning and clear liability on their part, and certainly the punitive verdict speaks to that. What was going on, why they didn't admit fault here?
So that is, I can't, concretely or, answer that question. But I said to Hannah, we're a couple days away from trial. I said, we got one shot at a big verdict here, and they can't accept the responsibility. And she's like, no way, they gotta accept responsibility. They rear-ended our guy. And what they tried to do was, we had no idea why this guy left the road.
Did you know why?
We didn't have direct evidence why he left the road, because he took the worst of it. He had a massive concussion. He had a fracture of his cervical spine.
Was he amnesic to the kind of the final moments?
Yeah, he basically, he didn't remember. What he remembered was leaving it happened about 5 minutes from his plant. And the last thing he remembers is, kind of heavy as snow. And then he blanks out. So what they argued was, we have no idea why this guy left the road. Just because you leave the road doesn't mean you were negligent. They also argued that my guy was in violation of PA CSA 33, it's either 3363 or 3353, that you weren't allowed to park on a limited access highway on the shoulder. So that increased the piss off factor when they turned around, and not only did they not accept fault,
they blame
my guy, who's just sitting in a tractor trailer with the four-ways on, completely off the road.
Was your guy cited or anything like that by the police?
No, not at all.
Was the other driver?
Yeah, he was cited for, driving too fast for the conditions.
But I'm guessing that's one of those, that's probably evidence you couldn't
It,
get the report in necessarily, and that's why they're like, oh, he was in violation of this and so forth.
Yeah, but
Okay.
what I was able to get him was like, they admitted that, through their expert, it was like, my guy, despite being parked on the side, he was never cited by the cops. And like, yeah, so that kind of put that to bed.
But that's basically the biggest gift is, so your co-counsel, and I'm sorry, what's her name again?
Hannah Molitoris.
Okay. So Hannah's skeptical, thinking they're going to admit liability in this case, right? And you're probably thinking that, but hoping that they don't. And here
Yeah.
they wind up not, which is going to be the best thing that could possibly happen to you, probably, right?
Oh yeah, it's, I got up and opening. Well, back to even jury selection. One of the questions we asked is, look, do you believe that truck drivers should be subject to more rules than regular drivers? And every single person, absolutely. And then we got a ton of people who are like scared of tractor trailers and everything like that. So we loved the jury that we got. Our opening, our theme was, to know the rules or to follow the rules, you got to know the rules. And then obviously, and speeding in a tractor trailer is dangerous because an 80,000-pound tractor trailer, speed kills. And then they get up, and again, they say this wasn't our fault. We have no idea. Nobody's going to tell you why. And one of the big things was our accident recon. So our guys pulled off on the shoulder. The tractor trailer veers off the road and then realizes it and comes back in, and kind of it's an offset rear end collision. So our accident recon says that speed doesn't play a factor in his analysis, because our guy wasn't like he was stopped on the road and they just slammed in the back of him. But the recon was just, he went right and he was going back. No matter what speed he was going, that's how the accident happened. So they kind of were, that was their big thing. They're like, nobody's telling you that speed's a factor. Nobody's telling you this. And they didn't accept fault. And then that led right into, we called the driver first. And we crossed him finished for the day, ordered the transcript. They come on, direct him in the morning, and then using the transcript, I just pummeled him with his answers. And then corporate designee gets up, same thing. He just didn't stand a chance.
The driver who got significantly injured himself versus safety supervisor or corporate rep, different. But I could see, in a sense, the driver could almost be a little sympathetic potentially. I mean, I don't know what he was like to deal with. Maybe he just was like a jerk. But I mean, was there any concern, or did you like softer cross him? And it was just more matter of fact, or did you take a more terse tone because of the fact they weren't taking responsibility?
Yeah, with not taking responsibility, I was very direct and let my lack of patience with their answers kind of come through. And the fact that one of the things they were saying was like, we can drive up to 10 miles an hour the speed limit because cops don't pull us over. And I was like, oh, do you have a document? And then the corporate designee repeated that answer. I was like, do you have a document that you could show to this jury that cops don't pull your 80,000-pound tractor trailers over if they're going 10 miles an hour the speed limit? It's like, no, it's an unwritten rule. I was like,
Oh,
okay.
wow. I mean, so I tell my associates sometimes, like looking back on my good verdicts, that there's a lot of luck involved, in the sense
Yeah.
that, like I mean, obviously you worked up a great case, you tried a great case, but it's a gift that you're given that they're going to take this tack. Like they literally have no leg to stand on, but they're still going to say, we're not at fault. We're going to blame your guy. I mean, you kind of can't ask for a better recipe for a potentially great verdict, right?
Oh, 100%. I mean, this, and I told it I got a bunch of calls from defense trucking guys. They're like, how'd this happen? I was very honest with them. I was like, if they came in here and said, look, this is our fault. This is just, we need your help to assess what the actual damages are. We probably don't even make it to punies, and the compensatory would have been lower than it was and what it was. But that's not the tactic they took. And again, they just fed, and the jury was just not believing, especially when their experts got on the stand. Actually, the second week of trial, so we closed the first week. The second week, they brought every expert in live. So Hannah and I just tag team. They had, three doctors from Penn. They had Dr. LaRue. They had their action recon and their industry guy. All came in live, and so it was a long week for Hannah and I. But they did, it just kept building into that theme that they weren't accepting responsibility, which led to how we got into closings, how we structured it.
Yeah, so I really, again, I keep saying I want to ask you this question about damages, but now that you bring up, the punitive component, Was this a case where you rolled right into punitives in this case, right? Did you get any financial net worth discovery at any point in time?
Funny you asked that. No, they did show us a document that their company's total net worth was $25 million.
Okay.
And I just made the strategic choice not to introduce that. And the defendants never introduced it. And I just wanted this jury to use their imagination.
Right. It's like a $1 billion trucking company or something.
Yeah. And one of the themes we played, and also in the compensatory in the closing, it's like, look, our guy's in a tractor trailer. This company is lucky that our guy was in the 80,000 pound tractor trailer. If him and his wife and their 4 kids were in a sedan pulled off on the side of the road, they would have been
Yeah,
obliterated.
they wouldn't even be here. Right.
And that resonated with them too.
So, because I think people are always curious about, because I literally was just talking with an attorney more in the middle state, Jamie Anzalone, and his.
Know Jamie very well.
Yeah. So Jamie got, that nursing home verdict, and he got,
Yep.
with the punitives in that case, but his was like a totally different scenario than yours. They had to bifurcate it. They had to try a separate case on punitives. They had to do all this discovery on financials and so forth. And so it's always fascinating how not uniform the application is of how, a punitives phase of a case is carried out. Going into the trial, I assume you had to move the court to, give you the instruction for punitives. Like what, do they find recklessness in the first place, right?
Yeah. So we bifurcated it, and then, which I loved because it set up the jury slip very well. Obviously we had recklessness against the driver via vicarious liability, and then we had recklessness against ECOR for their hiring, retention, supervision. Ended up pulling that from the verdict slip because the verdict slip kind of got a little messy. And so I just had, did you find the defendants negligent? Then it was, did you find their conduct to be reckless, both the driver and then the company, because they were assessing fault against my guy. But if they found recklessness, it didn't matter if they found, 50% of my guy, because you can't compare recklessness to negligence. So I had those check marks, and then it just kind of rolled into damages from there. And obviously, we got both checks.
Well, when you say bifurcated, did you do a separate additional close for punitives, or was it all wrapped into one?
So we did a separate. So we get the verdict on a Friday. It was like the 15th, and then defense counsel makes this argument that now we got to find that they're outrageous. And I was like, Your Honor, like, they found that they were reckless, and then in the
That's
definition
it.
of outrageous, it says you could be reckless indifference applies to that. And she's like, I'm going to hold it over. So we had to come back that Monday. So now, jury's been there for 2 weeks now.
Oh,
And defense counsel, I mean, his directs were super long, his crosses were super long. They didn't, they were done. But they come back on Monday, and it worked out great because two jurors couldn't come back on Monday. So I got 2 alternates who I really, really, really liked. And one of them, it ended up switching. The foreman from the compensatory was one of the people that were gone. So I got a new foreman. And when he read the verdict, it was kind of funny. But we had then they had a check mark for outrageousness. But we
you
did,
did have to
did
do
like
that. They had to
yeah,
go and then make a
she rolled.
decision on outrageousness too.
Yeah. And
Jeez.
for me, I handled it easy. I was like, look, you're going to hear the jury instruction from the judge. And in the definition of outrageousness, it says reckless indifference, and you've
Yeah,
already found
you
that.
already
So this
did.
is an easy one for you. It's just about a number, and the punitive, 5 minute kind of talking about how this is a once in a lifetime thing for them, that they actually get to effectuate change on our highways throughout the entire state, and the importance of punitive damages. And defense counsel let me argue this. I was waiting for an objection, but I talked about how, like, when GM's cars were blowing up, what made them safer? Punitive damages. When Johnson Johnson is producing, terrible medical, whatever, it was like, what made them safer? Punitive damage. I give like 2 or more things, and I just rolled in. And like, this is a company, and this tells not only Ecor but Schneider, Conway, all these companies that in our highways you don't speed, because if you speed, you're going to you're going to take someone's life. And so when the new foreman read it, they only gave 2,500 against the driver, and I'm sitting there, and all of a sudden, they said, "What do you give against the company?" And he goes, 25. And I'm thinking, shit, $25,000. Like, God damn it. And then he pauses, and he goes, million. And I was like, yes, but I had to do whatever I could to keep my cool, pretending like that is exactly what I thought you were going to do. And
Oh
meanwhile, I'm
man,
like, I was ready to jump up and
that's
down, but
that is freaking amazing. I'm sure you'll never forget that.
no,
Um,
yeah.
that made you sweat a little bit though.
Oh,
Um,
absolutely.
so all right, so I know I'm kind of going backwards a little bit now, but really curious. So I got two quick questions before I forget. So number one was
Yeah.
what was the compensatory amount?
So we ended up getting 1.2, which is, we client walked away from 1.485. So we went to mediation. That's the number that the mediator put on his proposal. Other side was prepared to pay it. And our guy looked at me and goes, no. And now our guy stopped driving a tractor trailer. Our wage claim was iffy at best. There were some issues with taxes not being paid. His Social Security came in, what he got paid on Social Security. And so they ultimately, like, the economics, and we had the futures, they gave him like 200 grand for economics. They gave him 300 grand for pain and suffering, and then they gave $700,000 for loss of consortium
Oh
to the
wow.
wife, who she's wonderful, wonderful person. Both people talked about how she had to step up while he wasn't working, and they had 4 kids, and talked about how difficult it was because his mood changed. He was getting angry more often. The fact that he couldn't go out on the road, and he was just sitting at home. But he also talked about, how he adapted and he was helping his, kids with school and things like that. But we ended up getting a bigger loss of consortium than we did economic and non-economic for the client.
Oh,
And
that's
so that got
great.
us to 1.2, which was less than what we were offered. But the client, like, I was expecting him to be, kind of upset. And, he, to his credit, he wanted to hear 12 people
Say it.
say it, and they certainly did. And even when they were trying to offer money, knowing that punitives were a reality over the weekend, and they put even bigger chunk of change on the table, and he said, no, no, sir, as he kept saying to me.
Yeah, so that's what I was, because I had read the 1.4 number somewhere, maybe it was on social media or something, about the offer before trial. So that literally was before trial. Then you get into trial. Before the punitives decision, was there any increased offers at that point?
Yeah, they signaled that they probably would have paid like 2, and we had offered them maybe like I pitched like a high low to them, and they had no, they didn't want to do it. And I'll be honest with you, I thought the 1.475 for this case, like, I thought he should have taken it. As I talked to my boss and our CLO at the time, I was like, I was wrong, and I'll be the first one to admit it. And it really did show me the power of what punitive damages can do in a trucking case, and has really altered my strategy, especially on the bigger companies that I know they got trucks, I know they got money, and I don't care if those penalties are direct against them and they're not recoverable from insurance. We will take your trucks, we'll
Right.
take your
Yeah.
assets, and it's just, so my demand goes sky high now to account for that.
Yeah. No, no, no. I mean, especially now you've seen what happened in this case.
Yeah.
One question I was really curious about is, so I saw that you guys had him evaluated through the TBI imaging, and you did, was it like the diffusion tensor imaging stuff to try to, see if there's, axonal shearing damage and so
Yeah.
forth. Did you get into that at trial?
We did. The downside was the guy that was the expert, Dr. Gonzalez, he like left the company, or he may have died. I forget which one it was, but like, so we brought it in through the treating neurologist, but it didn't really get too much into it. We talked about it. They brought in Dr. Kohler, who's a neuropsychiatrist from UPenn, who talked about it. Dr. LaRue talked about it. And the other thing I forgot to tell you is, one of their big defenses in this case was that my guy, the reason for his cognitive issues was the fact that he was abusing alcohol and smoking marijuana every day. That
So
was,
they were
and
trying to put that on him for that. And that's, I
which led
mean,
to one of my favorite comments ever.
which was?
Uh, so they kept calling it cannabis. The other side of the defense attorney was, older than, and Hannah and I. Hannah's even younger than me, and she looked at me and she's like, "When you're talking about it, like, just say smoke a joint." And so when
Yeah.
I was doing a cross, I said smoke a joint. You could see that, like, the younger people in the jury would just start laughing. Even the older people started laughing. But
Yeah.
then they were kept calling it cannabis, cannabis. So I said in my closing, I was like, all you kept hearing about was cannabis. It's like scary,
Yeah, right.
alcohol. And I go, you heard, alcohol and cannabis so much in this trial that if you just closed your eyes and never looked at my client, you would have swore he was the love child of a 21-year-old frat boy and Snoop Dogg. And that got a good chuckle from the jury.
It's a great line, man. Not to beat a dead horse, I'm just always curious about it. In hindsight, do you feel the DTI stuff is effective, or is it more trouble than it's worth? Because I've had it done, I've looked at it, and sometimes I'm like very unimpressed with the imaging I've gotten and so forth. What do you think?
I think in the right cases, had guy like actually treated for the head injury, like right off the bat, it probably could have been more effective. But the fact that like, 8 months had gone by and he, hadn't seen really, and there was like maybe one record saying, he didn't go to the hospital until like 4 days later. He slept overnight at a hotel, then got into his trailer was totally destroyed, but he got into his cab and drove it from Lancaster all the way down to Florida with no issues. And he doesn't really go to the hospital for about 8 days post crash. But there was really no mention of any type of, and even on his, like when he's going to the ortho, he's checking off like no cognitive issues, no headaches. So, was it effective in this case? I mean, the jury didn't really, buy, I think they bought it a little bit, but it wasn't very effective in this case.
Going back to your point, you talked about earlier, Eddie talked about it, and certainly Keith has written tons about it in Don't Eat the Bruises and Deeper Cuts about, the credibility component from the perspective of dropping, or leaving out stuff that you might just normally feel like, oh, I got to put it in there because I have it, whether it's a type of damages or so forth. Any big decisions that you and your co-counsel made as far as approaching this trial, things you left out, or, in hindsight, things, I mean, obviously you can't argue with the $26 million verdict, but
Yeah.
anything you would have done differently in that regard, or, what strategies did you use in that regard?
Our client wanted it all in, so there wasn't even an opportunity to say, hey, like we think this is a weak part of your claim, we should drop it. He wanted it when it wanted it all in, so we just had to stand up there and talk like we believed in it. We knew there was a chance that they weren't going to buy the whole thing, especially, I mean, the wage claim was tough. The
Yeah.
lack of taxes, and even the taxes that he filed, didn't show that he was making, a ton of money compared to what we tried to say is like, look, a truck driver can get $80,000 to $100,000 a year right now in Orlando, Florida. And we went through the job postings with the Voc. We went through them with their economist. They had to admit to it, but the Voc, Romy Tota, who I actually use a lot, was, I thought, gave one of the like a great piece of testimony. She said, "Yeah, that is for an over the road truck driver. Mr. Clemens chose to be an owner operator so he could be close to his family and get the benefits of that. So yeah, an over the road guy can make $80,000 to $100,000, but that, your client wasn't that." I was like, really, that's why I hire you.
Kind of final points on this case. Any other, I mean, you certainly referenced a ton of kind of those magic moments. I mean, just kill them with their first two own witnesses to start the case off. And then it sounds like you get into kind of a whole quagmire of medicine in the case. Any other of those kind of big turning point moments or great cross moments, anything like that comes to mind?
Yeah, actually 3 points. Like I already touched, like the wife did just a fabulous job, and they brought their youngest son, he's like 11 years old, and he sat through a couple days of trial. But when she's on the stand, he was there and he was just playing his game, and he was a real cute kid. And she pointed him out, and he looked up, and the jury looked at him, and he waved, and that was like a great great moment. But our client, we had an issue. We were about to play one of the medical videos, and something happened, and the judge was like, "Move on." I was like, "Well, this was the last one we're going to play." And she's like, "Move on." So the client who was going to go the next day, I looked at him and said, "You're
You're
up,"
up.
and it worked out perfect because he did. I wasn't sure how he was going to do up there, and he just did a wonderful job. We had a great connection. Especially talked about like he was a truck driver for 30 years, and I said, "How'd you get home? How'd you make it home safely? On 30 years on the road." And he was, prior to that, an over the road truck driver. He said, "Sir, I follow the rules. And you follow the rules, you make it home every night." And I was like, that was a good line, sir. But another good one was, the accident recon for them. he was talking and talking, wouldn't answer a question. And after 20 minutes, I'm starting to get frustrated. And the jury was too. And finally, I looked at him, I said, look, we can't, we obviously are not agreeing on anything, but you would agree with me, sir, that even someone's blind can't drive a tractor trailer. And he goes, no, I don't agree with that. I'm looked at the jury, and they're looking at me, and they started what is this guy talking about? And he gave some cockamamie answer. I don't even remember what it was, but it was after that, it was done.
Just
I had
made
no
the
more
point
credibility.
that, that's awesome.
And closing, really closing, I would say this real quick is just that what I typed, and the crash had happened almost 4 years ago. COVID had prolonged the case. And that's how I opened up. I said, look, for 4.5 years, or 4 years, this company, you heard a ton of words. You're here for 2 weeks. You had a ton of words from me, from opposing counsel, from all the witnesses. The 2 words you didn't hear were, I'm sorry. Oh, you didn't hear this was my fault. They had 4 years to do it. I said, and then they had 2 weeks here. And even if they didn't believe it, just for the optics, just come in here and say, I'm sorry. And they couldn't even do that because they just refused to accept responsibility. And it's a roll, right from there, and talking to the jury, that resonated with them.
So you had an opportunity to talk to them afterwards?
Yeah, we did.
I assume for that size verdict, it's a unanimous. There weren't any holdouts, right?
There were no holdouts on that one.
What were some of the other takeaways that they had to say about, anything that struck you unusual or interesting? I used to always talk with them, and I never talk to them anymore because it always just makes me crazy. But tell me what you heard. Anything interesting?
One thing I thought, there was actually 2 things in talking to them. Our treating neurologist, Dr. Maria Hubbard, it was kind of tough to understand her on the video. And one of the things they said, you should have closed captioning. It's perfect. Next time, we're definitely doing that. And the other one, the insurance company had an adjuster there every single day. And one of the jurors said, every time they would try and make a point, she would turn and stare at us to see, and she's jotting down notes, and they're it kind of distracted us from what the point they were making, and it kind of freaked us out a little bit. And I was that's also good to know. So when we go into the next trial, guys, we like to have three attorneys there and some people sitting. I was don't stare at the jury, don't do it,
right?
Don't make them uncomfortable.
Well, let me my little anecdotal point here about why feedback from jurors after trials I've just given up on listening to. So my partner and I tried a TBI auto case and got a decent verdict in last December. And I stupidly talked to one of the jurors afterwards, despite swearing off such behavior. And he was he's telling you all the good stuff you did because you won. He's well, one thing I thought that the defense lawyer did really well was whenever you guys had one of your experts on video or something, and he was cross-examining, when he was making a good point, he'd kind of look back at us. He's and I thought that was really good because that signaled that was something important that he wanted us to do. And then I'm listening to Mark Mandel on this podcast the other day, and he's telling an anecdote. It's the complete opposite, where a juror told him, you don't we're off put if you look at us and don't look at us. He's so this is Mark Mandel, guy wrote case framing and everything. And he's I just keep my head down when the jury walks in. And I'm well, and now here you tell this story. They didn't like that. So I just, stuff like that just makes my head explode, but it's still, I always want to hear it anyway though.
Oh yeah. But the one thing that always stuck with me, Professor Stride in Duquesne, says just be yourself. And for me, I can kind of be a little bit of a smart ass in trial, but I use the whole courtroom. I can't stand behind a lectern. I can't stand still. I like to go up, down, inflection, all that stuff. And that's just who I am. But that may not be who somebody else is. But as long as you're yourself, you're right. Somebody can do it, somebody doesn't do it. Doesn't mean it, can't work for somebody. No, it's just, if you sell it and then you're believable, the jury will like it.
Yeah, not to go down a whole mental craziness wormhole, but then you get into that, just be yourself, and then you lose a trial, and you're well, maybe I shouldn't be myself, But that probably had more to do with the facts and so forth of those cases. But anyway, Clancy, this is awesome. I thought, because I know you're on a freaking roll right now. You just hit this, what was it, 2.3 or 2.7 verdict recently?
Yeah, just under 2.6. It was 2.58 in Luzerne County.
on a rotator cuff case.
Yep.
Trucking case?
Trucking case.
All right. Well, here's what I would ask of you if you would consider doing this at some point. So we're at that, like, coming up on the hour mark, and I would want to give that case, if you'd be willing to talk about it, some actual time to dig into the details, because I'd love to know, like, how it all unfolds and so forth. And,
Absolutely.
you know, you just landed with your family and everything in Florida, so I just feel like now's not the time to get into it, even though I'd love to. But hopefully, you know, maybe in a month or two, I've got a trial coming up, things settle down, maybe we could do this again, and you could tell me about that case, because I'd love to hear about it.
Yeah, I'd absolutely do that for you.
Awesome. Well, I can't tell you how much I appreciate you sitting down. I remember, you know, like I said, seeing that email, this, you know, wicked verdict coming through, and I'm just like, man, I got to hear the story behind that. Appreciate you doing this. If people want to reach out to you, they got a big trucking case that happens out, you know, probably any part of the state, but, you know, in Philly or your parts, how can people get a hold of you, Clancy?
Hey, give me a buzz on my cell, 570-262-0809, or they could email me at cboylan@forthepeople.com.
Awesome. Well, Clancy, I'm sure people reaching out, you're kicking butt, and I'd love to hear it. And I appreciate you sharing your story with me. It's an awesome case. Okay. And thanks so much.
Definitely. Thanks again for having me on. This was awesome. I loved it.
You bet, man.
Thanks for tuning in to Trial and Medical Error. We hope our discussions have equipped you with actionable insights to lift your clients above the hurdles of medical malpractice litigation. Ready to refer or collaborate on med-mal and catastrophic injury cases? Visit our attorney referral page at pamedmal.com/refer. See you in the next episode.